What is the company legal opinion that is issued pursuant to the equity funding process? Well, to start with, it comes from the startup legal advisor or the attorney for the startup firm. And the legal opinion generally states matters concerning governance and makes other legal assurances to the investors. And the objective here is to, in some way, shift the burden onto the startup venture, and in another way shift the burden onto the startup lawyer to make certain that all of these things are accurate, and if they are not, to have some level of assurance from any malpractice or liability insurance that the attorney may carry. Now, the first thing he assures is that the company is validly incorporated pursuant to the laws of whatever state, and that it's registered as an actor in any given jurisdictions as a foreign entity in which it operates. The opinion states matters about authority to enter into this funding transaction, generally that it's been approved by shareholders and the board of directors. They make assurances that the capital structure as stated is genuine and that any agreements granting an ownership interest have been disclosed and documented appropriately. The issuance of shares pursuant to this agreement has been approved and is authorized pursuant to the Articles of Incorporation, and the bylaws are edited and amended in accordance with the agreement between the parties. All corporate actions being taken by the executives on behalf of the company, the individual is authorized to do so and has been appointed by the board of directors to carry out these activities. Any documents that are required to document the nature of the authority, the approvals, and all of that have been reviewed by the legal counsel and are in good working order. All government approvals needed for this transaction have either been attained, or that this transaction in no way conflicts with any governmental regulatory prohibitions or necessary approvals. Any registration with the Securities and Exchange Commission or State Securities Commission has been accomplished, or an exemption to that effect has been perfected and is in compliance with these regulatory regimes. Any litigation that is either pending or there is reason to believe could occur in the future has been fully disclosed to the investors to evaluate the scenario and situation. So basically, it is assurance of governance procedure, an assurance of compliance with regulations, and an assurance of disclosure of material and relevant information to the investors so they can make a sound decision regarding investing in the company.